Well, Gustavo, unfortunately I can't be with you in Buenos Aires for the launch of the Compliance Treatise book. I'm stuck in a wet and windy London. But may I thank you both, along with Thomson Reuters, for being given the opportunity to author the chapter on the UK Bribery Act, which is chapter 40, by the way. Fantastically good read, even if I say so myself. Since the book was written, I'm now a partner at DLA Piper in London, but still practicing in the area of work that we all have a common interest in, fighting corruption and economic crime. If you're ever in London, by the way, you're very welcome to come along and visit our brand new offices here. Since leaving my position as the head of the Bribery and Corruption Divisions at the UK Serious Fraud Office, my legal practice really mirrors the contents of the book, advising countries and companies in their bribery laws, assisting companies respond to whistleblower complaints, investigating red flags, reporting or responding to the authorities, the SFO, the DOJ, the SEC, the World Bank to resolve cases, and most importantly, developing first-rate compliance programs to avoid problems in the first place. So, the chapter on the UK Bribery Act, Chapter 40. Part 1 provides an overview of the Act, shows how the Act applies to any Latin American company carrying on part of the business in the UK, any UK company or individual conducting business in Latin America, or any Latin American company or individual acting together with those closely associated with the UK. As such, there are significant implications for Latin American companies, particularly those within international activities and those in the supply chain. The chapter also explains that it applies to both public sector bribery, government officials, state-owned enterprises, as well as private sector bribery, a significant difference with many other pieces of international legislation. Part 2 reviews enforcement trends, international cooperation, more cases, tougher penalties, incentives for self-reporting, and incentives for cooperating and reaching settlements, DPAs in the UK case. Part 3, very important, discusses how companies can mitigate the risks, and adequate compliance procedures are a defence under UK law. This final section gives an overview of the areas for companies to consider when developing new programs or strengthening pre-existing ones. Compliance procedures are a priority for any Latin American company to whom the Act applies. Compliance programs can't be bought off the shelf. You need special advice to deal with your organisations or your clients' organisations' bespoke needs and the dynamic risks that they encounter. So in summary, enjoy the chapter, enjoy the conference, enjoy the book, and don't hesitate to contact me if you're ever over in London and want to see DLA's offices here, or if you want any advice as to whether the UK law applies. Thank you very much.